Hello, my name is Jeff. This is 2A Self-Defense Law. What we do is we help people understand the law of self-defense in the simplest terms possible. We take the fear out of getting it wrong. Talking a lot about duty to retreat, stand your ground, and how people are getting it wrong, especially lawyers. Just because you have a degree does not necessarily mean that you know certain aspects of self-defense law. The reason I am doing this is that people have a gross misconception of what duty to retreat and stand your ground is. Now, stand your ground has actually more hoops to jump through in a lot of states than duty to retreat states. Let's back up a little bit. There are approximately 36, 37 states, somewhere around there, that have a stand your ground law. The rest are a duty to retreat. Now, for a majority of those states with the stand your ground, it was enacted with a statute, black letter law, where the state's legislature has gotten together and the Democrats and the Republicans starting to hash things out. And the Democrats would want to put in two situations where you had a duty to retreat. So yeah, you have more obstacles in a stand your ground state than what you do with a duty to retreat state, meaning that you are in a legal place to be, you are legally allowed to be where you are, and you're not creating a crime. And in other states, they put on more restrictions. Pennsylvania has a restriction of you have a duty to retreat if you are not being attacked by a deadly weapon, okay? Duty to retreat doesn't mean, like what some lawyers want you to think, that you have to egress out of your house for a duty to retreat, all right? And I want to make this clear. In every state has a stand your ground law. Let me back you out. Every state has a stand your ground. It may not be called stand your ground, but there is case law specifically saying that it doesn't expect a homeowner whose home has been broken out of a duty to retreat. That is said in every single state, and there is a caveat. Yes, your home has to be physically broken into unlawfully, all right? Now, when we're dealing with duty to retreat, the requirement is if you can do so in complete safety. If you're immediately attacked here and now, well, you can't do anything in complete safety. Some lawyers and some trainers will say, as soon as you have a duty to retreat, so yes, you have to turn your back to get stabbed in the back. Well, no, you don't, because you can't do it safely. So this is why I got back on the internet. Since I've been gone for a while, I wanted to see what was being put out there. And I was astonished about how many lawyers and how many trainers are getting duty to retreat wrong. Now, I'm going to be sharing a video with you guys. Now, this is a lawyer. He's obviously a new lawyer, and he's getting the views like you wouldn't believe, especially when he uses the word California. So I'm sure he's getting a lot of, God bless him. He seems like he wants to do the right thing, and we'll just go through it.
Also important for this, and I'm going to just quickly note here, and we'll jump back to it later on in the video, is that under California, we have a stand your ground law. And so when claiming self-defense, you are not required to prove that you tried to retreat or escape from the harm or injury that was being actioned on you. Under California, that is not a requirement. You are not required to retreat. And this is different from some other states, because some other states do require that you must retreat before defending yourself.
Not true. You do not have to have a retreat consideration before you can defend yourself. And if you are an immediate threat of death or great bodily harm and you cannot retreat safely, you can defend yourself right then and there. So the wording that he had is just not correct. Let's go with another lawyer.
The West Virginia Stand Your Ground Law, also known as the Castle Doctrine. And what does that mean? What does it not mean? Well, first of all, basically all it means in West Virginia is that there's no duty to retreat before using self-defense under certain circumstances. Primarily, this has to do with your home. So it used to be, and still is in some states, that say a home invader breaks into your home, they're trying to kill you, and you are required to escape if you have the opportunity, or lock yourself in a safe room, whatever. And if you chose not to do that, then you couldn't use the self-defense defense.
What?
Now, there is some good information in there, and part of it is this: if you are required by law to retreat and you don't do so, you lose the right of self-defense. And if the lawyer can prove that you could have gotten away in some fashion, then it was your fault. The main reason I want to get back up a little bit and talk about why stand your ground came to avail. Obviously, you need up to 5 standards to prove your case: innocence, imminence, proportionality, avoidance, and reasonableness. Now, one of the easiest ones to get to take down, the prosecutions to take down, is duty to retreat, because it was forcing you to prove a negative, that you couldn't go that way. How can you prove that you couldn't do something? How could you prove that Bigfoot doesn't exist? These are the aspects of what duty to retreat actually meant, and why, since the late 1800s, why stand your ground has become more prevalent is because of the weakness of trying to prove a negative. And for you people in California, guess what? You are a stand your ground state, and you are the original stand your ground state from the late 1800s. Okay. Now let's go on.
My name is Benjamin Von Shook. I'm a criminal defense lawyer in Cobb County, Georgia. Does a person have the duty to retreat before using self-defense in Georgia? When I talk about the duty to retreat, some states have a rule where before you can use self-defense, you have to try to escape by any means possible. If this means jumping out a window, or running away, doing anything to remove yourself from the situation, if there's a possibility that you can remove yourself, then you're not allowed to use self-defense.
Well, we went through this. The law doesn't require you to increase your risk, like going into a lake or going into a busy highway. They don't require you to increase your risk. They don't require you to run through bushes, etc., things like that. Now, this is a lawyer that I've run across before, and I like him. I really do. I don't know if this was just an admission of saying something factual, or him just not knowing, but he's out of Michigan. He's handled some high-profile cases, and it's a little bit on the lengthy side, but we'll get there.
Let's talk about it. You know, there's only 2 kinds of, I'll call it, opportunities you have when it comes to use of firearm outside your home. I'm referring to either stand your ground or duty to retreat. And I liken it to being pregnant. You know, you can't be a little pregnant, or nah, I'm not just pregnant yet. You're either pregnant or you're not, right? So with duty to retreat, you have to understand you either have the duty or you don't. Ohio, and again, correct me if I'm wrong here, has not passed a stand your ground law at this point.
No, not at this point. Keep trying.
They're trying, right? So that means that in Ohio, before you can use lethal force to protect yourself, you have to have an escape route. You have to at least try to escape. Now, here in Michigan, we have stand your ground. And let me just kind of compare and contrast the differences. If I'm at a gas station.
Well, let's get back to that before it gets too far. And again, what he's saying, that you have to have a retreat consideration. No, not if you can't do it safely, and not if you're in immediate threat of death or great bodily harm. I mean, happening right now. The gun is out, the knife is coming to you. You do not have to have a retreat consideration. All right, let's continue with this.
and I start to pump gas, and you know, let's say 3 guys walk up to me. They're mean, they're ugly, and you know, they're wearing Ohio State stuff. I'm just kidding. Okay. I'm a Michigan State alum, and I am very fine with the Buckeyes. So,
Lawyer
let's say
humor.
they're wearing some, you know, they're looking pretty mean, and they come up and they say, "Hey, give me your wallet, give me your cell phone." Okay. Now, in Michigan, I don't have to do anything. I don't have to run away. I can stand there because I'm not doing an illegal activity. In other words, I can stay there and protect myself. In the state of Ohio, if something like that happens, the first thing I have to do is look for an escape route. Now, does that mean that I get to run away, like behind me, in front of me? That's the first thing I have to do. And if there's no escape route, then and only then am I allowed to use lethal force for my protection.
Now, you know, the law is not going to have you prove that you couldn't do something, that you had a retreat consideration. Oh, well, I considered about going this way, but no. Oh, I considered going this way, but no. If you couldn't do it safely, and if it was immediate, here and now, where if I don't act, I'm going to be dead, the law is not going to require you to have a retreat consideration. This next guy has come a long way. I've had some issues with him in the past and have had some dialogue with him in the past, and he's one stubborn SOB. Again, it was over duty to retreat in Florida. Now, he's a Florida instructor. He's not a lawyer. And basically what he was saying, the same thing, is that you needed to turn your back and have a knife 3 inches into you before you can have defend yourself. And I told him that's not what the law is. I sent him a case law. And what actually happened is that he removed all his comments, and then a little bit later he removed all my comments. I am pleased to tell you today, after this video, he's heeded my advice. Let's go with it.
Prior to the stand your ground law, Florida had a retreat law, which means that if somebody attempted to attack you, rape you, stab you, you were required to attempt to run away if you could do so safely.
He didn't have those last few words in his book. He didn't have those last few words in several videos. Now he has it in his videos, if you can do so in complete safety. Now, I haven't spoken to him since the last video, a year and a half or maybe 2 years from now. So he may not be able to admit that he is wrong. However, he will use the information later. And, you know, I want you guys to take me with a grain of salt also. You know, look this stuff up. Prove. I want you to prove. If I'm wrong, please tell me. There was the last time that I remember being wrong, or someone told me they're wrong, that a lawyer told me that self-defense was an affirmative defense. And in many jurisdictions, it's not. The word affirmative defense, and if anybody else uses the word affirmative defense, has really modified itself over the last 50 years. Affirmative defense used to be that you had the burden of proof and the burden of persuasion. The burden of proof that it was self-defense, and the burden of persuasion to tell the jury, yeah, it was self-defense. No state requires that anymore. Ohio was the last one for you to prove that it was self-defense, being switched on to the prosecution to prove beyond a reasonable doubt that it wasn't self-defense, to eliminate innocence, eminence, proportionality, avoidance, and reasonableness. So I learned that it wasn't affirmative defense. I don't use the word affirmative defense anymore because I was wrong. The lawyer who said that it was not a affirmative defense wasn't a self-defense case any longer, because the prosecution has the burden of persuasion now. You know, I took that in. I can modify myself, okay? The greatest obstacle to discovery isn't ignorance, it's the illusion of knowledge. Sometimes people who, when they get that knowledge, can't go beyond that and say that they are wrong. Okay, let's go on.
Listen, if somebody's trying to stab me, can I ever safely run away? That's ludicrous.
And so,
So the reason I put him in this video is because he has changed. Now, this is Mark Victor, the person on the left. I have tremendous respect for Mark Victor. The person on the right, but the person on the left, I have tremendous respect for. Okay, now we're going to get into the lawyers who are telling you what I am telling you, and they are right.
you know, we always talk about that Arizona has no duty to retreat in a very proud kind of a way. Well, since I've been licensed in Hawaii, I've had occasion to very carefully go through some of the Hawaii statutes in this area, do a little comparing and contrasting. And Hawaii's rule is very different. It's really the opposite end of the spectrum. I want to focus in on this difference that I have thought about a little bit, because Hawaii's rule is a retreat state. And so you have to understand what this means. First of all, we're only talking about a situation where you're going to use deadly physical force. So you don't have to retreat if it's ordinary physical force. Okay. So we're talking about mostly you're getting ready to pull your firearm and maybe discharge a round or something in that neighborhood. And so what Hawaii says is, if you are planning to use deadly force, you must first retreat, but only if you can do so in complete safety.
There it is. Only if you can do so in complete safety. So I want to make sure that you guys who are in a stand your ground state, that you really realize that even though that you do not have a duty to retreat in your state, you do have a duty to retreat if you are not in a place that you're legally allowed to be and you're committing a crime, okay? If those are something that you're not sure about, you have a duty to retreat, okay? Now, then it falls back onto you saying, if you do have a duty to retreat, you don't have to retreat if you can't do so in complete safety. So I want to make sure that you understand, even if your trainer is saying that you do not have a duty to retreat, you possibly can, because of two factors. If your state requires you to have two or more conditions on you, so you don't have to justify stand your ground, you will have a duty to retreat, especially if you live in those soft stand your ground states where the finder of fact in the jury can see if your reasonableness was so out of whack, they can go back and say, he had a duty to retreat because he was so unreasonable. So those are the two factors of what stand your ground and duty to retreat are happening for people in this nation. Don't listen to an instructor or a lawyer saying we live in a stand your ground state and we don't have a duty to retreat. Yes, you do. My name is Jeff. This is 2A Self-Defense Law. I hope this helped.